Hello, my name's Tim Penny. I'm a barrister at 11 Stone Buildings, specialising in commercial litigation and in particular commercial fraud.
I'm Laura Newton and I'm also a barrister at 11 Stone Buildings, dealing primarily in commercial litigation and arbitration.
What are we going to cover today, Laura?
We're going to be dealing with the Section 25 of the Civil Jurisdiction and Judgments Act 1982 and explaining how the English courts can grant injunctive relief in support of foreign proceedings and some of the principles from the case law. Then we're going to deal with enforcement of foreign judgments in this jurisdiction and some of the practical considerations. And finally, we'll be drawing on our own experience to give you some tips from practice as to things to look out for and potential pitfalls when you're making this type of application.
So the scenario is this. You're consulted by a Russian bank, and the Russian bank has lent money to Russian companies, and the loans to the Russian companies have been guaranteed by the chairman and chief executive of the Russian companies, Mr. X, who the bank believes owns the Russian companies. The Russian companies have defaulted on the loans. The bank has sued Mr. X in the Russian courts under Russian guarantees which contain Russian exclusive jurisdiction clauses, and the bank's also sued the borrowing companies under Russian loan agreements with Russian jurisdiction clauses. Mr. X has told the bank that he doesn't have any assets. So the Russian bank consults you in the English jurisdiction about obtaining a freezing order, a worldwide freezing order or a domestic freezing order against Mr. X and his LLPs in this jurisdiction, and asset disclosure orders and any other orders that the English courts might be able to grant because the availability of such orders in Russia is very limited. So we're going to cover what relief the English courts might be able to grant to your clients in support of the Russian proceedings.
Under Section 25, the English courts have jurisdiction to grant relief in support of foreign proceedings where the substantive claim is in another jurisdiction. And that might be Russia, as in this case, but in fact it can be proceedings in any country because as a result of the legislative changes, this section now applies to proceedings in any jurisdiction around the world. First of all, we've got to establish that we would be entitled to the relief that we are seeking if the substantive proceedings were in this jurisdiction. So, for example, looking for a freezing injunction, we would need to meet the English test, which is that we have a good arguable case on the merits and there's a real risk of dissipation and that the court should exercise its discretion to grant a freezing injunction. And that's stage one.
Perhaps I'll deal with firstly the Credit Suisse and Quogi case, which was the first time that this jurisdiction had been considered in any detail in the Court of Appeal.
That's often an argument that's raised against you when you're making a Section 25 application, isn't it? That the relief isn't available, for example, in the Russian courts, so why should the English courts intervene? But actually, the very policy of Section 25 is that the English courts can fill a lacuna in foreign courts' remedies and the relief that's available to them.
That's where Van Uden is particularly important, because the ECJ decided and held that in order to be entitled to rely upon this jurisdiction, there must be a real connecting link between the subject matter of the measures sought and the territorial jurisdiction of the court where the measures are sought. That was taken up by the Court of Appeal in Motorola, which is the next case you're going to deal with.
Yes, the Motorola Credit Corporation and Uzan number 2 was a really important decision, I think, and it's one that set down a number of guidelines which are important to bear in mind when making this sort of application.
I add as a postscript that in the latest saga in the VTB litigation, having obtained judgment in this jurisdiction, the claimant applied to the commercial court and extended the domestic freezing order to a worldwide freezing order against the defendant, but excluding assets in the state where the substantive proceedings took place.
Right, so that's quite an important development, isn't it? You know, getting a worldwide freezing injunction of a parasitic judgment on a judgment.
And it just shows that the court is prepared to use the Section 25 jurisdiction in novel situations in order to attain the purpose behind that jurisdiction.